I wanted to start off today with the timeline briefly of the activity with regards to the DS-1 form and in particular litigation surrounding it. Starting back in April of 2018 up through June of this year, and ongoing issues that will be getting submitted, if not directly or informally, with the department through their request for non-binding statement process, of which I'll explain more later in the webinar here this morning. It is also relevant with regards to a later slide regarding IDFPR's rationale considerations in terms of some of the decision making they've made with regards to recent activity that they shared with the association yesterday. Getting into more of the substance though, if anyone hasn't seen it, it is linked in this slide and linked in the chat and will be shared with the registrants after the finish of this webinar. IDFPR put out a settlement memo shortly after the agreement was reached, and it highlighted the date of the settlement of May 20th with regards to recent litigation. It also highlighted the use of the 1997 DS-1 form for up to 3 years from May 20th, and unless, and that's the language that I'll also touch on, but the unless an intervening amendment to the act or other binding change in law, of which the department did make some indications yesterday to the association with regards to how they viewed potential future work on the act and its authority. With regards to the settlement itself, the first section after the whereas clauses is the first dot point referenced here on the slides. It's also what the department put in its memo. So the memo slide that was linked online is what the department utilized in its memo from section 1 of the settlement agreement. In some ways, it appears that section 2 is where there are some discussions in the industry in terms of various interpretations of what it may have meant for compliance, which was what, in some ways at least, led to the association reaching out to IDFPR to get some clarifications. Some things to note from that section 2, the second dot point on this slide with regards to enforcement of the 1997 form is the aspect of two provisions, basically the first two sentences with regards to phrasing that the department agrees not to take any enforcement action. So there's two provisions in that section 2 of the settlement agreement with regards to the quote, department agrees not to take any enforcement action in the first and second sentence. Without speculating too much, the second sentence with regards to what the department agrees not to take any enforcement action on is where there appears to have been some discussion of what it may or may not mean. And as noted before, was one of the things that the association focused on when reaching out to the department for clarification. So the what does it mean, and we'll get into it in the slides here in a moment of some of the specific questions that were presented to the department, of which we got some responses to yesterday that we are sharing today. One thing other than the language just mentioned that it's important to at least highlight that for some in the industry caught their attention is the phrasing with regards to the receipt of a percentage of the premium in terms of what does that mean or what is that referencing, and how the department will take action or not take action going forward. The other thing I wanted to highlight before we moved on to the other slides is while this section 2 of the settlement agreement and the second dot point on this slide does reference the receipt of a percentage of the premium, It does not reference the agent registration type or reference that type of status. It also doesn't appear to reference business incorporation status. And I make note of that largely because that does appear to play a part in the department's response to a question that the association submitted. An overview before we get into some of the specific questions that were submitted and some of the answers that the department gave and suggestions that the department had yesterday. An overview, as we just touched on, regards to the May 20th settlement, we do have it linked and will share as was noted to the registrants, of which you can disseminate to any of your colleagues in the industry with regards to the settlement agreement language. IDFPR's main questions to ask regarding who this impacts. So this was something the department suggested be a framework for those continuing to ask questions with regards to compliance with Section 18 of the Title Insurance Act and the DS-1 form, of which comes from that. As you can see there, they are suggesting some main questions to ask of, are you making a title insurance referral? Who are you making the referral to? Do you own them? I think we all know that there is more to all of this than just that, but that is a suggested framework that the department is inviting the industry to use it, at least initially, with any questions you have. We'll also provide some of the statutory definitions that are, of course, important. And as always, while we're not giving any advice when providing these webinars, we do want to share the information that we have been provided by the regulator in terms of how the regulator has indicated it will handle its enforcements, of which I'll note now the department is very clear that it can only speak for itself and what its intentions are, not necessarily other levels of government or branches, but do want to share this to the industry, of course, as soon as possible. In addition to the framework generally that the department provided, they did provide some clarification, of which will show some of the exact language that was submitted to the department and some of the hypotheticals that will continue to be worked on. In the June 1st settlement clarification from IDFPR, bullet point, the third one down, the first dot point under there relates to the language in the Section 2 of the settlement agreement. And so the department clarified its intention of that language and what it agreed to, that receipt of only premium percentage does not equal ownership on its own. So that was a clarification that the department did confirm. The next part, a next dot point on this third section on this slide was referenced before or planted the seed before when mentioning the lack of some language with regards to the registration type that an agent may have, as well as the business incorporation status that an agent may have, not maybe being in language in a way in the settlement agreement that was crystal clear. So some certainly have had questions, and there have been some interpretations that appear to be floating around the industry. Again, it's why we reached out to the department. This is a summary of their response, of which I'll get to in a moment, their specific response and the question that was submitted. But in short, a solo attorney, not part of a law firm entity and registered as an individual agent, does not trigger DS-1 requirements. Again, we'll get into that just a little bit more here in a moment. But also in this overview slide, wanted to provide links to the old DS-1 form, which quote unquote old form, the 1997 form, which remains in effect, again, for up to 36 months, unless the law is changed. Resource updates we will continue to provide on our news page for the association. And finally, on this slide, for the overview of what's going on, non-binding statement request working group. We'll touch on more what this is a reference to from the administrative rules that the department is recommending future questions go through. For members of the association, we will be having our first work group meeting June 9th at noon. It will be virtual. The link is there to register. We will hopefully, with board approval, have discussions of potential questions to get further clarification on and have those submitted by the end of the month. So it'll be a healthy couple meetings, hopefully this month, but try to knock it out for everyone's time and efficiency this month, and also just the time sensitive nature of everyone needing to know the various compliance questions that are still out there. So what has been clarified, what still needs to be clarified? In the association initial request for clarification, a question that appeared to be circulating in the industry that would impact many individuals and entities involved this first dot point, and so was submitted to the department in this manner. If an attorney is acting as a solo attorney, not an owner in a law firm entity, and is registered as an agent as an individual, does the DS-1 form need to be completed, assuming all other elements are met for a DS-1 form being needed? The answer that the department provided yesterday was in clear terms, no IDFPR will not be seeking enforcement of the DS-1 form in that scenario. So the department has made it clear, at least with regards to that hypothetical, what its plans are with regards to enforcement of the DS-1 form. In parentheses, right below that dot point, we do want to note that this June 1st IDFPR statement will be submitted pursuant to administrative rule requests for non-binding statements. But for now, we do at least want to pass along that clear response from the department. With regards to related hypotheticals that were posed to the department in conversations yesterday, you can see a few examples of how there are still some clarifications that some of the industry are hoping to get, and some of which you can see build directly off of the initial hypothetical. Whether or not a non-attorney in that same scenario and same situation as presented before, the answer would be the same with regards to the department's enforcement intentions. That was actually one of the first questions presented to the department after its answer of the hypothetical with regards to an attorney acting as a solo attorney, not an owner of law firm and registered as an individual. The department, as most regulators will do at times, doesn't want to potentially answer questions before it's ready, and so did defer that question, and at the time actually made its recommendation to start submitting some of these through the non-binding statement request laid out in the administrative rules. So no clear answer on that question yet. Solo attorney registered as an entity and otherwise meeting DS-1 requirements was an example of a hypothetical the department may be getting. It's something that the association at least want to identify as a question that's out there, both for the industry as well as the department. This potentially would be a reference to the situation where a attorney, while a sole practitioner, is still incorporated in some shape or form to do business in the state of Illinois, whether it's an LLC or PC or in some other fashion. Attorney registered as an individual, but at a law firm and otherwise meeting requirements. So again, all other elements being met for the DS-1 requirement. The question is, does a one or two tweaks in the scenario change how the department would view enforcement of the DS-1 form? The attorney registered as an individual, but a law firm is something that the association is aware of happening at times in an industry where an attorney may be at a firm, however, their registration status is not through the firm, it is them as an individual. So that is something that the association will be working on to get clarification. As noted in the final dot point of this slide, the June 1st IDFPR clarification and the related hypotheticals will be submitted for non-binding statement pursuant to its administrative rule citation. The working group, as noted before, will be hopefully working on that and working to get answers by the end of the month, or at least having the questions submitted by the end of the month. The next scenario that we presented with regards to a request for clarification was really based off of the first scenario, but not focused on the individual who may be triggering or involved in the transaction and the referral, but more in terms of the first sentence of Section 18B of the Title Act, and again, Section 18 being the section that is the main authorizing section where this DS-1 form comes from. And 18B pretty clearly lays out some prohibitions with regards to issuance of title or providing services when the disclosure is not made. And it puts those prohibitions on underwriters, independent escrowees, and agents. In short, the request of the department when providing its clarification. The first hypothetical was, so we want to make sure that you're not going to be enforcing this against the other entities as well. And in short, as you can see here, the department indicated that under the same scenario as was presented on the last slide, the enforcement will not be made against any of the other entities listed in Section 18B. And so did want to provide that clarification. As you can see in the other related hypotheticals and parenthetical, we do also want to make sure to submit that, though, through the non-binding statement process to make sure we get clarifications of that and get it in writing. Again, IDFPR has made clear that their position is only speaking for how it intends or doesn't intend to enforce the DS-1 form, and would not necessarily be speaking for other levels of government or branches of government. Rationale. I think that some in the industry are interested in what the rationale of the regulator is and some of its positions, and how that could be helpful to those of you with continuing questions. And so some of that rationale may be useful in coming to conclusions you may be wanting to draw in the meantime, before we are able to get official non-binding statements. The avenues of rationale that the department provided yesterday are summarized here in these three categories, and wanted to touch on just a couple other nuances. In the category of the department looking to have a focused use of its regulatory resources, like any bureaucracy, there's only so many people and money. The department highlights that. The department also highlights what was noted early in this presentation with regards to the timeline. A lot of work went into the quote unquote first litigation that spanned years. And the department is interested in efficient uses of its resources in terms of when it's looking at the potential litigation that it may or may not have, as well as looking at what the form actually does and what it is in terms of its use to the department as a regulator. That's something the department highlighted in terms of where its rationale was for settlement and its enforcement decisions going forward. It ties into the next point with regards to the Title Act authority limitations, which was a big part of the 2018 litigation in terms of looking at and negotiating what the limits of the department's authority is. It certainly appears to be part of the recent litigation, and the department certainly agreed to terms in the settlement agreement for up to 36 months unless the Title Act is changed or some other authority with regards to state law. So with regards to this category, the department indicated it does not have any imminent plans to propose changes to the law, but explicitly invited the industry to, and those that may be interested in reforms or authority expansions to have those discussions with the department. The association is here to promote best practices and protect the industry. So as always, the association will work with the regulator, but be vigilant in any expansion of authority that the department would have. And want to at least point out that we certainly all know, or most know on this webinar, that there have been discussions for market conduct reforms in the past, and they're likely to continue in the future. So that may overlap with some of these DS-1 form discussions with regards to the department's authority. Finally, the last category that may be of interest to some was a comment with regards to the rationale considerations of the department in terms of its decisions on when enforcement will happen. This is a reference to the hypothetical of a solo attorney registered as an individual agent. When trying to press on the various situations that can happen with regards to how an individual is registered or how an individual is working in the state of Illinois, whether they are or are not in some type of business structure under the business acts and in our statute books, the department indicated that it is seeing some difference in whether or not somebody is simply acting on their own as an individual, registered as an individual, not as an entity, and whether or not they are acting in some form as an entity that's licensed to do business in the state of Illinois. Their comment was, while there are benefits of incorporation, there are also responsibilities, and wanted to pass that along to those on this call and who may be viewing this recording in terms of the department's thought process of how it views individuals versus entities. Some of other considerations as we're getting close to wrapping up here, and this is more for reference only with links to the various sections. Again, these will also be relevant sections if there are discussions with regards to the department's authority in the Title Act. Section 3 provides definitions, 3 in particular, that are relevant to the DS-1 form discussion: producer, associate, and financial interest. Section 18, again, is the section that's core to the DS-1 form. That would also potentially be a point of discussion. And within, tucked in the middle of the Section 18 is also a reference to Section 19 of the Act. In Section 19 of the Act, some may read it to be viewed as a limiting section that prohibits the departments from regulating it in certain areas with regards to rates and fees. But it does list out some line items of the types of rates and fees that are in the industry. And there's a reason that it is tucked into then Section 18, but it also elicits another area of questions. While we provided some hypotheticals that we hope the association working group is able to come to consensus on to submit to the department, there remains other areas beyond just the registration status as an agent or the license status as a business in the state of Illinois. One of those areas where there continues to be questions is the quote unquote other fees line item of the 1997 form. Some of the questions on other fees do appear to mimic some of the questions that were proposed in the quote unquote new form that was the subject of litigation, where there was the et cetera on that form. One thing we would at least want to point out for those continuing to try to decipher what should or shouldn't be disclosed in some of these line items is that section 18 references, and we have linked here section 19. You will be able to see that when going to section 19, there are some similarities in language from the statute and the form with these line items that may be helpful to trying to decipher what fees are or are not disclosed. And finally, while not providing any advice on this at this point, and certainly not wanting to commit the association to any future advice that may be provided, at least want to let folks know that we have more than one level of government in the United States, and some of you may want to consider federal law and CFPB and RESPA with regards to some of the questions that are coming up with regards to the DS-1 form. And in particular, we've linked Regulation X Appendix with regards to a disclosure statement under federal law that may be relevant as we go forward in some of these discussions. It is also worth noting that the definition of financial interest in federal law was something that was discussed as a potential change to Illinois law in Senate Bill 4023, which contained both what I just referenced with regards to financial interest, along with many other aspects of the market conduct reform proposal, but did want to share that as well with regards to the definition of financial interest. With that, we're just over the 30-minute mark. Wanted to make this a short lunch and learn for everyone, and at least get out the information that we have from the department so far, and the continued work that we as an association, and I'm sure other interest groups, will be working on, if not individual companies. We hope to share anything we have. We hope others will share the association as well as we try to get answers to this and any other questions that industry members come up with over the next month, so that we all can have at least an answer on how to comply. I'm sure next year or this fall, we can have fun with conversations with what other terms may mean with regards to ownership, referral, or who should or shouldn't be complying. For now, we are just trying to work on getting answers to what it means to comply, so you don't get your hands slapped by IDFPR. With that, I thank everyone for your time. I invite any members to join our working group who are interested in trying to submit non-binding statements requests by the end of the month. And I hope everyone has a good rest of your day.